Hi, this is Erica Merrill, and I am the founder of Perfect Legal Video. I'm very excited to bring to you today another exciting episode of SVL Insights. And leading the charge on the information that we get is attorney Jim Sorenson. He is a founder at Sorenson Van Leuven, and they are out of Tallahassee. They represent credit unions. And the information today is going to be on the topic of Replevin, and it's the very first of a new series, I believe, that you have come up with called What Is. And so I want to welcome you today. Jim, thank you so much for joining us.
Thank you, Erica, for having me. Yeah, we are excited to start this new series, and we're going to be doing a What Is series and just providing some basic information on various rights and remedies that are available to our clients and through the courts and what they mean and how they work. So I'm excited for this new series.
Me too. I'll certainly miss the myths, but the what is also great. I love definitions and lists. So let's start off with the definition, which we often do. What is a Replevin?
Yeah, so a Replevin is a type of lawsuit that is used to get possession of a piece of personal property that is in the possession or control of another person or party. So think about it in the typical scenario is the credit union makes a loan to somebody. That loan is secured by a lien on a vehicle, and that vehicle is in the possession of the debtor borrower. There is a default on the loan, and the credit union now wants to recover the vehicle. So the legal process for that is a Replevin, and that is just one example of a Replevin.
So is a Replevin a universal term, or is it different in different parts of the country?
Yeah, this term is not universal. In different states, it will be called different things. In Georgia, it is known as a writ of possession, but in Florida, it's called a Replevin. I believe in some other states it goes by different names, being licensed in Florida and Georgia. Those are the two that I'm familiar with.
So I know with certain things in law, there's a statute of limitations, and you can only take a certain action for a certain amount of years. Is there a statute or rules that govern the Replevin action?
Yes, in Florida, there is a statute. It's in Chapter 78 of the Florida statutes. And this is the statute that governs and sets out the Replevin action. It lays out the process that is required. It lays out where the lawsuit must be filed, which court it's filed in front of, and it sets out the general procedures and processes that the parties must follow and the court must follow in this type of action, in a Replevin action.
I mean, that's interesting. So where does a Replevin action have to be filed?
So under the statute, it has to be filed in, there's basically four options when it goes to filing the lawsuit. You have to file in one of these four things. It either is filed in the county where the property you're seeking is located. So if you're trying to recover a car, you would file it in the county where you think the car is located. Or you can file it where the underlying contract was signed, if there's a contract. Replevins aren't always contract-based. I'll give you an example where one isn't. Let's say in a relationship, someone has a boyfriend, girlfriend, or maybe it's just a friend, and they lend them their car. And once the person starts driving the car, they refuse to give it back. So one of the ways you may have to go about getting your car back is a Replevin. Obviously, in that scenario, there's typically not a contract. So where the contract is signed wouldn't come into play. The other two options are where the defendant resides, so where the person you're suing, where do they reside, or where the cause of action accrued. And that can depend upon several things. Sometimes the contract defines where the cause of action accrues, or it may be where the certain event takes place. So again, going back to the example of you lending a friend your car and then not returning it, If you demand that they return the car to you by X date to your home, and they fail to do that, the cause of action would accrue in the county where you live. So in a lot of these cases, there's more than one county where you can file the Replevin action. Once you identify where you can file it, which county, you then have to identify the proper court. And in Florida, we basically have two trial courts. We have the county court and we have the circuit court. And the county court is for claims that are $30,000 or less, and the circuit court is for claims over $30,000. So in a Replevin action, you're not asking for money damages, you're asking for the return of property. So the court's jurisdiction is based upon the value of the property. So if the property's value is $30,000 or less, you file in county court. If the value is $30,000 or more, you file in circuit court.
I mean, that's really complicated. I had no idea that you really had to look at which county and then which court. That sounds like a great reason to use Sorenson Van Leuven if you're in this area. I'd rather just ask you than try to figure this out myself.
Yeah, it does get complicated at points. And sometimes we've had cases where, we think the property is in, ABC County, and later it's determined, no, it's in XYZ County. And the case may have to be moved or refiled in another county. So this can get complicated sometimes.
Right. So I'm just wondering, how do they even determine what the value is on the property? Because, I mean, a lot of times you and I talk about kind of pleasure vehicles like RVs or boats or things of that nature. And, automobiles, all of those things, the second you take them off the lot, they have a huge decrease in what their value is. Is there a process, and what do they do if so?
Yeah, so the process is usually you would look to an authoritative reference guide. So for automobiles, motorcycles, boats, RVs, those all have guides out there that will set valuations. They set a retail valuation, a wholesale valuation, a loan valuation. And those are guides like the NADA or Kelley Blue Book. There's others, but those are the two that are more known. And usually that's what the court is going to rely upon. So if you can show the court that you relied upon the NADA value, or you relied upon a Kelley Blue Book value, and it's, the accurate month, you can't obviously rely upon a NADA from a year ago. It's got to be a current valuation. The court's gonna rely upon that, but sometimes there is collateral or there is property that we're trying to recover for our clients that aren't in those types of books. So, I've had to do, for example, large ride-on lawnmowers, like a zero-turn John Deere lawnmower. It may be, originally it was $8,000, and they financed the purchase through the credit union, and they've defaulted on that loan, and that lawnmower, the credit union wishes to recover, and those aren't listed in an NADA or Kelley Blue Book. So in those cases, we have to go and we have to look at, what is the average sales price. And so we typically will go to places like Craigslist or Facebook or other places where people list that sort of a property or equipment for sale. And we pull several valuations and average them, so that if the court ever asks us, why did we say the value of this riding lawnmower was $4,000, I can point to specific examples of where those were list price for the lawnmower. It's not an exact science, but normally those are accepted by the court.
Wow, that's really interesting. And I'm glad that they do that, because it'll show the current value instead of like what they bought it for, I guess. That's pretty important. So, but you have a really special reason to use Replevins, because of your practice. So why do most of your clients file a Replevin?
Yeah, typically, it's because my clients have an outstanding lien on a motor vehicle, a boat, an RV, or a motorcycle. I mean, those tend to be the pieces of property we're pursuing. And that lien secures a loan, and the loan is in default. And our clients have been unable to repossess the property. Usually they cannot repossess it because either the defendant is hiding the property or it's locked inside a garage or behind a gate or fence, and the recovery agent, the repossession agent, can't get it. So they have to resort to a Replevin action, and so those are assigned to us. And we've had some weird examples. I remember one time there was a guy was keeping his motorcycle inside his apartment, so the repossession agent wouldn't get it. He was literally taking the motorcycle in the apartment, and the front door was large enough that he could wheel it inside. Obviously you can't do that with a car or with a boat or an RV, but you can do it with a motorcycle. And so sometimes we get into fun, weird cases like that.
Well, that is interesting. I don't know if you know this, but you do definitely know that I bought an RV this year, but also that I just turned in my big Jeep Wrangler for a Mini Cooper. And I swear that thing can fit into so many small spaces. I'm like, if I had some big double doors, I'm sure I could drive that thing right into my house.
And someone has probably tried that, Erica. Someone has probably tried that.
That's true. So let us know a little bit about, I think you could absolutely write a book about all the interesting stories with Replevins and how people have tried to hide their property in other places. And you've even told me stories about them bringing it to another state and just getting RVs. Hey, you can just move in and drive away with it, right? I mean, do they have to take their property across state lines quite often?
Yeah, sometimes, the property will move across state lines. And so, you will have a Replevin action in Florida and they go to Georgia, and now we've got to file a similar action in Georgia. Again, it's a writ of possession in Georgia, but we'll have pending a Replevin action in Florida and a writ of possession action in Georgia. And if it's something like an RV that they can live in, right, that they can move from campground to campground. So they could move to Tennessee or Alabama or South Carolina and on from there. So literally once we had a guy in a camper that we were traveling, he was traveling and we were chasing him all over the country, trying to get that RV.
Oh my God. Oh, wow. That is, that's definitely, you can write that book. I'd love to read that. Just have something amusing. You have a lot of interesting things that you write. That would be really a fun thing. I know you're not even allowed to share most of the details because of attorney-client privilege, but it's definitely fun. So what are the general steps needed to file a Replevin?
Yeah, there are in Florida, there are two different types of Replevins. And so the process can vary depending on which one you're going for. One requires a hearing before the writ is issued, and the other Replevin is what is referred to as a prejudgment writ of Replevin. It's issued without a hearing. I think the prejudgment is somewhat misnamed because there isn't a traditional judgment in a Replevin action. At the end you get an order issuing the writ. And so really one is with a hearing and one is without a hearing. And when you're seeking either Replevin, the first step is we have to prepare a petition, an affidavit. The affidavit is signed by the client, and it sets out the basis or the grounds for the client's right to the property in question. So in the case of a defaulted loan, it sets out that, hey, there was a loan made to John Doe. John Doe pledged his 2020 Honda Accord as property, as security for the loan. John Doe is defaulted on the loan and not paying pursuant to the terms. He owes this much. and we have been unable to recover the property, and he refuses to surrender the property. Those are the basic allegations. And so you put that in the petition. There's an affidavit, which is a document signed under oath where the client is verifying the information is accurate and true. And so those are done in both cases. But in a standard Replevin case, we also prepare and submit to the court, along with the petition and the affidavit, what is called an order to show cause. And this order to show cause, it's if the judge will accept the filing and the paperwork is in order, the judge will sign the order to show cause. That sets a hearing in the case. And that order to show cause now orders the defendant, and it reads basically that the defendant has to either surrender the property to the plaintiff, to our client, or appear at this hearing and establish why they're entitled to retain possession. So in other words, if you have a defense, if you don't believe the credit union has a valid claim to the car, you have to appear on this date and time in front of the judge and establish your right to retain the vehicle. And so that is how a typical or run-of-the-mill Replevin, if it is a pre-judgment Replevin, meaning there will not be a hearing up front, then the other part of that is that the plaintiff must file with the court a bond, a court bond, and that bond is twice the value of the property. And that bond is posted with the court as protection to the defendant, so that if the defendant loses possession of the car, they are protected. So any claims for wrongful repossession, any claims for wrongful recovery, there is a bond that they can make a claim against, and it's for twice the value of the car. So if the car's worth $40,000, the bond would be $80,000. So if, let's say, the plaintiff gets possession of it and the car is destroyed while the court's waiting to determine who's really entitled to it, now the defendant would have a claim against the bond for the value of the car, their costs, their legal fees, and so that's how that process works. So again, either we file the paperwork and there's a hearing, or the paperwork is filed with a bond and the judge issues the writ right away.
Can you pursue a pre-judgment Replevin in every case?
No, you can't. So under Florida law, pre-judgment Replevin, the one that happens without a hearing, the plaintiff must show or establish, and this would be based upon what's in the petition and in the affidavit and any documents that we file, that the defendant is engaging in or about to engage in conduct that may take place and place the property in danger of destruction, concealment, waste, or removal from the state. So, destruction would mean they're going to destroy the car. Concealment means they're going to hide the car. Waste means, and waste would be, typically that's not a car, but it's more of a situation where it's collateral that could be damaged if left out in the rain or left out in the weather, or that typically doesn't come up in the type of cases we handle, but it does come up in some cases, in some commercial cases where you might have collateral that could deteriorate real quick. And then of course, removal from the state is simply they're going to take it across state lines and try to get it out from the court's jurisdiction. The other ground to pursue it is a transfer to a third party, that if they are threatening or there's a likelihood that they're going to transfer the property to a third party, or that the defendant has failed to make a payment under a contract. So in a contractual case, you generally always have this right. In the case of, the boyfriend lets the boyfriend lets the girlfriend borrow the car, and the girlfriend refuses to return it after they break up, that isn't going to be a case where payments were due. And so the boyfriend, if he's going to pursue the car through a pre-judgment writ of Replevin, would have to convince the court that the girlfriend is likely to destroy the car, hide the car, or take it out of the state, or transfer it to a third party. So that's how the pre-judgment Replevin works.
So what happens once the writ of Replevin is obtained?
Yeah, so once the writ of Replevin is obtained, it's sent to the sheriff, so the sheriff in the county where the property is located. And the sheriff will go out to serve the writ. writ. So what that means is they're going to go out and try to recover the property. So, typically we will tell them, hey, John Doe has possession of the property and he lives at such and such address. So the sheriff goes out to the address and the sheriff says, hey, I've got a court order. I'm, here to take possession of the 2020 Honda Accord or whatever it is. If as part of that writ, sometimes we can get what's called a break order. And the break order is an extra order that is required if we want to authorize the sheriff to get access to a locked gate or enter a locked garage. Sometimes the sheriff will go out and say, okay, I went to the property, no one was home, but I saw the car and the car was in the garage because I looked through the window, or the car was behind a locked fence. The sheriff cannot just go and cut the lock based on the writ of Replevin. So we have to go back and get a break order, and the break order now authorizes the sheriff to cut the lock and get through the locked gate or get into the locked garage and get access to whatever it is that the writ of Replevin applies to.
Wow, that is so interesting. I mean, I don't even know why people try to keep property that they're not paying for. It sounds like a really embarrassing situation to have the sheriff there trying to break into your property so that they can take what you didn't pay for. But I mean, this is the process, and unfortunately some people drive you to do this. What happens once the sheriff recovers the property?
Yeah, so once the sheriff has possession of the property, the sheriff will turn it over to the plaintiff's repossession agent. So the sheriff's offices don't operate like a repossession agent. They don't have a tow yard. So usually the plaintiff's repossession agent will take possession of the collateral depending on the property, depending on what it is. So if it's a car, if it's a boat, RV, they're going to tow it to a tow lot. It's going to sit there pending sale of the vehicle. And then it follows the standard sale process just like you would in a regular repossession. So once the time periods have expired and the car can be sold, the car gets sold just like any other repossession.
Wow. So in the past, when we've talked about this, we've talked about some of the mistakes that credit unions may make when trying to get their property back. And I know that this can be quite serious if mistakes are made and you're taking someone's property away and selling it and you didn't have the right to do it yet. So can you tell me, what's the one big mistake that your clients make when it comes to Replevins?
Yeah, I think the one big mistake that I see more often than it should is that clients forget that once the property is recovered, in most of the cases it's a car. So once the car is recovered, prior to selling that vehicle, the lender is still required to provide proper notice of their intent to sell the collateral. So just like a repossession, there is what's called a notice of intent to sale letter that must go out. And it informs the borrower, it informs anybody who's obligated on the loan that, hey, the credit union is now in possession of this vehicle. The vehicle is going to be sold under its rights under state law to satisfy or to apply the proceeds towards the outstanding debt. And it gives the borrower the notice that the sale will happen after a date certain, typically 10 days or more. And so the borrower now has a final 10-day period within which he or she can pay the loan off. So if in that 10-day period they can come up with the whole amount owed and pay that to the credit union, the sale won't happen. They'll get their car back. And what happens is a lot of times the clients know they have to do that in a repossession, but they forget they have to do that in a Replevin as well. It's the law applies to both. And so sometimes we see that where they just fail to do that. And failing to do that can lead to a claim for damages. It can get expensive. And so, I want to remind credit unions or other lenders who are watching this video, that's something that you should be doing. It should be part of your procedure. And of course, as with anything, related to Replevins, if they have additional questions or need help handling a Replevin, please reach out to me or one of the other lawyers at our firm. This is what we do. We handle Replevins quite often. We file several, a week, and always have several going on. And like we've talked about, some of them do get interesting from time to time.
Well, thank you so much for keeping us informed on the Replevin process and the mistakes that could happen. Really appreciate it. And this is, like always, a lively conversation and very interesting. Who knew that credit union law could be so exciting? So if there are any credit unions out there watching this that are not yet using Sorenson Van Leuven Law Firm for situations like this or many others, please do give them a call, because they're excellent. They're very knowledgeable and they treat you like family. They've got an amazing staff. So thanks again for coming on for SVL Insights, Jim. We really appreciate it.
Thank you. Looking forward to talking to you again soon.
Thank you. Bye-bye now.